within its own finances for taxing and spending within the state government.
Couldn't the Fed stop them, Edwin?
No. That's the beauty of it doing it through the states.
Talk about that.
The states have a residual sovereign authority. Remember, the states were originally separate countries, independent countries, right?
I don't think people think of it like that.
Well, they don't, but it's the truth. And they formed a union of these 13 independent states, these 13 independent countries. And they gave some of their authority to the general government, the government in Washington, D.C., and they retained other parts of their authority. So we have this federal system which has governmental entities at different levels, from local, state, national levels. Now, one of the governmental powers that the states did not give up, and this has actually been held in cases that went to the Supreme Court of the United States, was the power to choose whatever the states wanted to use as their own currency for the purpose of their governmental activities. Well, that's taxation, borrowing, spending, eminent domain, courts, you run down the list of governmental activities in which a state is involved. The state can choose its own currency. It's not going to be bound by what Congress may emit or what Congress may authorize. And in fact, there was a case called Lane County versus Oregon in the late 1800s in which the state of Oregon had a statute that required that taxes be paid in gold. And tax collector actually at the lower level had collected legal tender paper currency that had been issued by Congress, so-called Lincoln greenbacks of the Civil War. And the question was the state required to accept this legal tender currency that Congress had emitted, notwithstanding the state had a statute that said it would accept only gold? And the Supreme Court said, no problem. The state is a governmental entity, and Congress cannot tell the state what to use as currency, as money, for its own governmental purposes. So that's the end of that. A state now can pass a statute saying, we intend to use gold, we intend to use silver, we intend to use gold and silver. We're not going to use Federal Reserve notes anymore for our state governmental purposes, and that's the end of it.
So what
state now goes off the Federal Reserve system.
What states are you seeing that are close?
Well, I think New Hampshire's going to go with this again. Montana, last year, it was in committee and didn't get out of committee because they have a Republican-Democrat pretty much 50-50 split in the Montana legislature. I don't think they have a session this year, but they do next year. Idaho, the people in Idaho looking at it. There were people in Indiana looking at it. There were people in Colorado looking at it, Missouri. There's a similar bill that uses gold coinage in the state of Georgia. So what did I say, 5 states or 6 states so far that I know of that are looking at this. And there are others that are rumored to be looking at it. And as this year develops in terms of the economic downturn, I think it's going to be worse this year than it was last year. I think there'll be quite a bit more pressure for a statute of this kind to be laid on the table in various state legislatures.
Do you think
because they'll be desperate for looking for an alternative?
Do you think that there's pressure on state servants and leaders to not go with this type of a gold money bill as legal tender because they want federal funding for things or support or help or bailouts? Or do you think that could form resistance to going ahead with something like this?
Well, I think pressure will be brought on them from a number of directions to stop them from thinking about this kind of legislation, let alone enacting it. But if you look at the federal bailout situation, if what the federal government is saying is we're going to give the state, $10 million in Federal Reserve notes if the state complies with some program, all right. They send the $10 million in Federal Reserve notes down to that state, and the state converts them into gold, and that's the end of it. Nothing can prevent the state from converting the Federal Reserve notes into gold anyway. They can take all the Federal Reserve notes that the government in Washington wants to send them and convert them immediately into gold. There's a big gold market out there in the rest of the world,
Absolutely.
And then the state operates entirely on gold. And the federal government wants to send them these gifts, as it were, fine. I think the difficulty is that you would see it coming out of Washington, the other kind of limitation saying, we won't give you some kind of payment from Washington if you have that kind of an alternative currency system in place.
So it takes somebody very strong and visionary and forward-thinking.
Well, he just has to look down the road and realize that in a few years those Federal Reserve notes coming out of Washington will be worthless. The system is collapsing. What's the point of staying tied to a dead horse?
Well, they all know it's a dead horse.
Well, I don't think they all do. I think some of them are coming to that realization. But then the point becomes that if your state or local, so you're a state politician, and you're going to be tied to this dead horse in Washington, well, Washington's not going to help you at that stage. You're going to have to answer to your local constituents. And you'll be out of office or worse.
One of the things that I think would help get more people involved in purchasing gold and silver and also get involved in being part of goldmoney.com is for there to be more attorneys who can do gold contracts. I know we spoke a little bit about that when I first talked with you, but I really think it's a part of the key that people don't know how to do contracts surrounding payment in metals. And so if that were all of a sudden more available, in other words, if it wasn't such a distant thing way out there, like if it became more accessible and you can bring the contractual part of how do you do a contract in metals, because some people think that it's against the law to do contracts in metals. Can you speak about that?
Well, it's certainly not against the law. That's point number one. There was a period in time from 1933 until 1978, in which contracts of that type, made in gold, not necessarily made in silver or other currencies, but made in gold, were not enforceable. There was a statute that made them not enforceable. So you could write one of those things, but if something went wrong, you couldn't take it to court and have it enforced.
What about now?
1977, they repealed that. Congress repealed that law. And people who want to look this up, it's Title 31 of the United States Code, Section 5118D, as in dog, 2. And actually, if you read that, it's very clear because it refers to contracts of a certain type. But you got to read the whole bloody section to try and understand it. But that's essentially what it means. The gold clause contracts are legal. And a gold clause contract is defined in that particular section, 5118 of Title 31 of the United States Code, as a contract that requires payment in specified gold coin of the United States. That particular term, gold clause contracts, is kind of generic because it includes contracts that could be written in silver or contracts that could be written in foreign currencies. So it's kind of become a generic term. But these things are legal. All they require is that you be very specific in defining what it is that will be used as the exclusive medium of payment for a contract. So if you write a contract that says the payment will be $500, that's not a gold clause contract, because contract of that type, where the dollars are not defined in any way, can be paid with anything that Congress has declared to be legal tender for a dollar. So they could be paid with Federal Reserve notes. It could be paid with these base metallic coins, the Susan B. Anthony coins or the presidential dollar coins that they've put out. In fact, the debtor in that situation would not pay in gold. He would obviously not pay in silver. He'd pay in the cheaper paper currency or the base metallic currency. But if you wrote the contract to say $500 payable in 10 $50 American Eagle gold coins of the standard of 1985, et cetera, et cetera. I mean, there's a lot of things that you could put in that'll really specify it. Then those 10 $50 American Eagle gold coins would be the sole medium of payment allowable at law for that contract. Those coins would be the only legal tender for that contract because the contract had so specified. One simply has to know how to make that specification. And if you have a payments clause that specifies that way, then the courts are going to be required to enforce it that way. Actually, I would tell any lawyer, suggest to any lawyer, that you put an arbitration clause in there, so you keep the thing entirely out of the courts. If anything goes wrong with that contract, have an arbitrator make the decision.
Isn't it the same or similar having an arbitration? You're still stuck in the courts. You're still paying not quite the same amount of money. Can you make that distinction for us?
Well, the distinction is an arbitrator is a private party that we have contracted to settle any dispute that arises